Hi everyone, I'm Dale Smith, aka Journo Dale, and we're here to talk about Canadian politics. This last week, the Supreme Court of Canada struck down a particular law, but invited Parliament to come up with a new version of it that would be charter compliant. And this got me to think about what we think about when it comes to the dialogue between the courts and Parliament. And this was kind of an example of that. It was a law, not getting too deeply into it, but it was a law that was something that was responding to a Supreme Court decision in the early 90s. And it was very controversial, and Parliament went and passed a law afterward as kind of a response. And it wasn't a great law, and nearly 30 years later, it finally made its way back to the Supreme Court, and they said, no, this wasn't a good law. It's overbroad. It impinges on some fundamental rights. And so we're going to strike this down. But again, it was with this caveat that yes, you can create a law around part of this in order to capture the aspects that are the social harms that they're really trying to address, but do so in a way that is charter compliant. And they even offered a couple of different possibilities that Parliament could consider within the decision, which is pretty significant because, the court is giving Parliament a roadmap where they don't normally, or they don't often do that. We've seen other cases where the Supreme Court will strike something down, but they will give what they call a suspended declaration, which means usually it's like you have 6 months or you have 12 months to come up with a new law to replace this, in the interest of there not being a vacuum in the law in the meantime. And Parliament will take that time, usually, and come up with a new legal framework. We saw this with medical assistance in dying. We saw this with prostitution and sex work laws. Parliament doesn't always get it right the next time around, and that's sometimes a problem, particularly if because these are often challenging and moral issues. Parliamentarians can be fairly timid about this kind of thing, so they will try and push things as far as possible and hope that the court won't strike it down again, or that it will take some time to do so, as we're kind of seeing right now. One of the other ways in which dialogue happens is with reference cases, and that's where Parliament can go to the Supreme Court and say, we want your opinion on this particular law. Is it constitutional? Usually that happens after something is passed, or it's a question on a topic that they want to legislate on. So they're looking for some kind of guidance from the court, which can be very fraught because sometimes the court doesn't necessarily give straightforward advice on how to do something. They will kind of give some general principles, and Parliament would have to work around that. If you want some more on references, I am currently reading Courts Without Cases by Charisma Mathen, who's a professor at University of Ottawa and sometimes guest on this channel. As you can see, I'm about halfway through, but it's interesting because she's looking at the history of reference cases. And this is something that's actually fairly unique in Canada, that our Supreme Court does references as well as the highest level of appeals. Other countries will have a constitutional court to do that. So that's kind of unique, somewhat in Canada's circumstances. But this is also where some of that dialogue becomes really interesting and small p political. Like we were saying, parliamentarians can be very timid, or we could even say outright cowardly on some particularly fraught social issues, and they will try and get the Supreme Court to force them to do something and kind of make the court the bad guys and not them. We saw this a lot around things like same-sex marriage. The government at the time was basically dragging their feet on legislating this after a number of court defeats, and sent a series of questions to the Supreme Court as they were trying to come up with the legislative framework around this. This was partially just dragging their feet, but it was also an extent to try and charter proof what they were attempting to do, or to figure out what the bare minimum they had to do was. And one of the things that was particularly noteworthy in that is that one of the questions the court declined to answer, because they could see that it was an absolutely political question that was not for them to answer. It was for Parliament to basically decide on and then kind of take the heat from afterward. And we see that with a number of things, particularly rights issues. LGBT stuff in the 90s and the early noughties in particular was very big on governments, largely provinces, but also the federal government, needing to be defeated enough times so that they could say that the courts forced them to extend these rights, which again is one of these things that doesn't really count as dialogue, but it is the interplay between Parliament and the courts, in particular the Supreme Court. Now, this all having been established, there is some criticism among political scientists that this notion of dialogue is a little bit overwrought, because oftentimes the court will still strike something down after Parliament goes back and drafts a law. Essentially that the court is always getting the final word, and it's not much of a dialogue in that case. But I also have to point out in that particular regard that sometimes Parliament does at least get their own way for quite a while, because as we saw in this case that I was talking about this week, that was nearly 30 years between the law that Parliament passed and it coming back to the Supreme Court, because it was something that happens. It's a very rare particular issue, but that it took that long to return to the courts means that for a generation, what Parliament decided stood. So it's hard to say that it's necessarily a completely one-sided issue. But yeah, this is part of the interplay in our system, why we've got a separate judiciary from the legislature, and why the two kind of have this tension between them. And that's generally a pretty good thing in our democratic system. So yeah, this is when we talk about the dialogue, that's what it's referring to. And it's also something for us as voters to keep an eye on, is how much are our politicians trying to get the court to launder the hard decisions on their behalf. I think that also is something that we should be aware of, and when politicians are being particularly timid in trying to do the right thing on the hard questions, because they're afraid of the backlash and they want someone else to blame for their going ahead and doing what is ultimately the right thing. And that's everything for this week. Join us again next week for some more Canadian politics. I'm Dale Smith. That's at journo_Dale on Twitter. And don't forget to like the video, share, subscribe, and support us on Patreon. Thanks, everyone.